So I'm talking about disciplinary and termination in today's environment. Interestingly, over COVID situation, there wasn't a lot of disciplinary type matters because people were off in their own separate places and weren't doing so many terrible things. Although we did have some, inappropriate messages through to other colleagues using the platforms that were in place. So they didn't completely go away, but they're certainly coming back out to the fore as businesses have gone back into their workplaces. So it is really important to get disciplinary processes right. We frequently see mistakes being made, including things like not correctly outlining allegations, hardly or not following a process, or an outcome that's just not really justified in terms of the facts. So today I'll talk to you a bit about how to get that right. And you say, well, what is a disciplinary process for? Because we do think of it as being to terminate, well, many do, to terminate an employee, but actually it is supposed to be used to address conduct that the employer doesn't want to see repeated. So we're normally talking about some wrongdoing, some misconduct. It's not necessarily done with a view to ending employment, and of course that feeds into your requirement not to be predetermined as to the outcome, but of course it can end an employment relationship, particularly when we're talking about serious misconduct. If we're talking about things like lateness, just being rubbish at doing the tasks associated with the job, maybe some skill gaps, etc., then that's going to be a performance management process. Now, we don't have time to get into the specifics of performance management today, although I was asked to touch on a couple of points, but many of the process steps that I will talk about today will, of course, apply to performance management. So we just note, of course, that with performance management, the process often ends up being longer, and there is the requirement to give staff the opportunity to improve, for example, which can take some months, and for that reason is something that employers are sometimes quite not scared of, but don't want to go down that track. But it is better to tackle any of these matters, whether it's disciplinary in the form of misconduct or performance management, as soon as possible. It's a really good rule to run by. So some key concepts, we've got the concepts of good faith and the justification requirements underpinning everything we do in these disciplinary processes. So, of course, the principle of good faith underpins most things that we do in the employment space, and requires both parties or all parties to deal with each other in good faith. Section 4.1a also has the obligation to provide employees with access to information relevant to the continuation of their employment where an employer is proposing to make a decision that could adversely affect that employment. And so that provides the basis for a lot of the steps that we have to follow. 103A, Section 103A, of course, sets out the test that we look at, our objective test about whether the employer's actions or how they acted were what a fair and reasonable employer could have done in all the circumstances. There are two essential elements required in terms of assessing a dismissal and whether it's justified under the Act. It's our substantive and our procedural. So substantive, was it sufficiently serious to justify dismissal, if that's what we're talking about? Do the facts support the outcome, and was it serious enough or of a magnitude that justified that outcome for what happened? And then the procedure, of course, must be fair, and there are a number of steps, as I'm sure you're aware, but we'll touch on those today. So you've got an issue, you really need to assess the allegations. You might have a complaint, you might have witnessed someone doing something wrong, you might have discovered an irregularity that needs to be looked into. So the nature and severity of the allegations are going to dictate what you do. There's no one size fits all, but there are the general principles that we apply. Just as through COVID, we had the bulk and the fundamental principles from employment law that we could apply to a new environment. We do that all the time, depending on what allegations we're looking at, and tailor the process appropriately. So what the steps taken should be proportionate to what we're talking about. You might need to get an independent investigator involved. That's very common in bullying situations or allegations, but also where you might need someone external or independent to look into the issue being raised. That could be because of the person against whom the allegations are made. It could be the nature of the allegation or just the setup of the organisation. But of course that is not necessary, and so many allegations do not require an independent investigator to become involved. But it is important to make sure that you do make inquiries and find out what's going on. Things like speaking to witnesses and getting statements, finding more out about what surrounds the issue. So there might be some procedural errors in understanding what the requirements are and where they're documented. And basically all of those inquiries should be documented and then provided to the employee. If they are things that you are going to be relying on and as a part of your decision making, then they should be provided to the employee. And what we've seen over time is a requirement to provide more and more. Once upon a time we would write a letter and would say, oh, this is what you've done wrong, Johnny, what do you say? But now, there's been a lot more in terms of case law about the standards required and what needs to be provided to the employee. So essentially, if you think of it, that if you're going to be relying on it to make your decision, they're entitled to see it, and that provides a really good rule of thumb. Employment agreements and policies, of course, are one of the essential starting points as well. One of the first things you check, have one of the terms of the agreement or policy been breached? What are we hanging a hat on here? Keeping an open mind, of course, but if you don't follow your own employment agreement or policies, then that can result in a breach of procedural fairness. And it's amazing how many times that happens. People just go down a track and they don't actually come back to the documents that all that trouble's been gone to prepare. So, there's an example might be if the employment agreement says a warning needs to be issued for this type of conduct before dismissal, and the employer moves straight to dismissal. Now, if your employment agreements say that, I'd suggest you get them changed. But if they do say something like that, then you need to be seen to be following your own process, or you'll get yourself into trouble. Suspension is worth consideration at an early stage. Is it needed? Can you do it? Depending on the nature of the allegations involved as to whether it's appropriate. In order to suspend, we are usually looking for a clause in the employment agreement to support that. In deciding to suspend, you also need to show that you acted fairly and reasonably. So there's often conjecture over whether a suspension was lawful. Certainly a lot of employers just simply say you stood down or you're suspended or just go home while we sort this out. And it's really important to remember that any of that phraseology will be interpreted as a suspension, and that what you need to do is tell the employee that there is a proposal to suspend, give them the opportunity to comment on that suspension, and then make a decision on the suspension. And often that is done very quickly, because often the suspension is something that needs to occur. It's better if the full allegations can be provided to the employee at the same time, but you don't want them, you're not asking them to comment on the full allegations, it's just around the suspension. Often though, an employer is needing to go away and find out about some things or look into things before they can give the full letter for the disciplinary process, but they need to get that staff member off site. So it's an area where it's tricky and it requires quite a lot of understanding about suspension in order to be able to execute it, because it doesn't tend to go as script. Probation and trial periods, of course, are worth looking at the early stages as well, because they might apply. As we should all know, the trial period requirements change, so we're now 19 or less employees means that a trial period can be used, and above that, many are using a probation period as an alternative. So it's important to remember that the courts interpret particularly trial periods very narrowly, and it's important to remember that termination under the two regimes is different. So we saw as we moved away from the predominance of trial periods that some employers were making mistakes around termination under probation period. So for trial periods, of course, notice can simply be given and the employee can't raise a personal grievance in relation to the dismissal. Remember, of course, that they can still raise a grievance about other matters, for example, disadvantage and the way that they've been treated during their employment. So that's important to remember. And it's also, of course, worth going through the various factors that you need to have in place to be able to rely on a trial period, that you've got the signed employment agreement, that it's a properly worded clause, that it was signed in sufficient time before the employee started, which helps to demonstrate also that they haven't worked for you before, and to check that point generally as well. So that is where a lot of people have fallen down as well. And of course, with probation periods, they're different and intended to give the employer an opportunity to assess suitability of the employee. And where you look to rely on one of those, a justification of that decision is still needed. So a process is still required. And it's really important to remember that with a probation period, an employer can't wait until just at the end of the probation period to try and do something before they take any steps. So that requires the issues to be raised more formally, and the employer to work with the employee to try to get them to the right place. It's not something that you can do overnight or at the end of the probation period. So that's really important. So you've got these issues, you now need to feed it into a disciplinary process. So it's really important to make sure that you are setting out the issues and that they're set out properly, that the person going to the meeting, the employee that you're raising the allegations against, goes knowing exactly what the allegations are and all of the information that is against them, so to speak, avoiding predetermination, and explaining the reasons for the concerns and setting out all of the supporting documentation and attaching it. So procedural fairness, as we know, is an essential element of justification under the Act, and it's really important to make sure that all of the procedural requirements are met to avoid personal grievances being raised. So we've got Section 103A with these minimum requirements for a fair and reasonable process. And so the factors that the court will look at to test all of this includes whether the employer carried out a sufficient investigation, and that's going to be having regard to the employer's resources. So a much larger organisation is going to be held to a different test from a ma and pa business with one or two employees, likely. Whether the employer has raised concerns with the employee before dismissing or taking this action, whether the employee had a reasonable opportunity to respond to the allegations, and whether the employer genuinely considered the explanation before reaching a decision. So those are basic requirements of natural justice that imports into these processes. So there's a number of things that I'll touch on around these procedural things. So notice of allegations. So you've got to make sure that the allegations are properly put to the employee. And as I said before, it's all matters that are being relied on, including supporting information. And that includes things like the identity of a complainant or witness. And that can be a difficult point because often people want to raise issues, but they don't want their name put alongside it. So, it's really worth going back to those people and saying, well, in order for me to be able to do anything with it, I do need to be able to name you. How do you feel about that? And to try and at least go back at least once. I mean, you can't sort of harass them, but we usually find that people often say, I don't want my name attached to it, but when they understand why we need it, then they are a lot more willing, particularly if they do want something to be done about it. The opportunity to be heard, so that's the employee's opportunity to be heard by the decision maker. So we frequently see people trying to get someone else to run the meeting because the decision maker is too busy. Granted, that's probably correct, but the principles of natural justice do require the decision maker to hear the employee. So it's really important to get that stacked up and to also think about along the track and how long this is going to take. Other things that sometimes happen is, suddenly the decision maker's on leave and no one thought to raise that. So, really thinking those things through. Of course, we all know that employees have the right to be told of their right to representation, including having those people at the meeting that you have. The actual requirements of procedural fairness, once again, might vary depending on the allegations that have been brought. So if we've got an employee who has been caught with unauthorised possession of property, maybe caught on video camera, and they don't really provide any explanation, then a bare confirmation of the facts may be enough. But if we're talking about perhaps maybe more of a performance matter, if someone's pretty incompetent, then you might have a much longer process involving warnings, opportunities to improve, a lot more detail around what it is that demonstrates this so-called incompetence, might be examples of work, and so that type of process can be a lot more full. We often have employees who don't cooperate, and so there is the good faith obligation to be responsive and communicative that we can rely on to try and get employees to engage. More commonly, we see it around delay for disciplinary meetings, for example, and really we need to entertain that to a certain extent, even though often we're biting our tongues as to how frustrating that can be. In fact, often just schedule that into your time frame and then you won't get so annoyed with it, because what employers tend to sit on these letters, ring someone up the day before, and then that person says, well, I can't prepare you for this for tomorrow. Sometimes it's a tactic as well, but sort of one adjournment is probably reasonable if there's some genuine reasons put forward. So, but there can be some other tricky issues, but there are also some tricks that can be used. And although we can rely on the obligation to be communicative and responsive, we can't just sort of jump in and say, oh, well, that's it, you haven't given us your response and you had to do it today and you said you couldn't come, so we're going to make a decision. That's not reasonable. We also often have medical issues affecting participation. And the genuineness of that can be questioned at times, and sometimes it does have a detrimental effect on their health, or other times they just happen to fall unwell, and we just need to tread really carefully with that. Reasonableness would dictate that you wouldn't push forward with a process while someone is genuinely unwell. But it doesn't stop you from asking them if they would like to or are prepared to have the meeting still, giving them the option. But often we do end up having to delay the process for that. But then sometimes it's actually the process that's caused the stress. And so often, actually, in realistic terms, that person's not going to feel any better until the whole thing's over anyway. So that's often a bit of communication, and that can be helped a bit or hindered sometimes if they're represented and you can work with that person. Avoiding predetermination is another key factor, of course. So there's a number of factors. It comes down to the language that is used by the employer throughout. The language in the letter cannot be predetermined, and that's where a lot of people trip up. They go in, particularly if they're doing it themselves, and they're saying, oh, this happened and you did this and all of this sort of stuff. Other things that can complicate that is where you've had a manager or someone early on who has before you've started the process, they might have said, expressed a view on who was in the right and who was in the wrong, for example. So if possible, depending on the structure of the organisation, it would be better to pull away from that person as decision maker if that type of conversations happened. Also in meetings, being careful about the language used there. And then also, of course, the making of the decision. So case law is really clear that even if you go away for 15 minutes and have a wee talk about it and think about it and come back and talk to the employee, that is not sufficient time to have properly considered their response, such that means you're deemed to be predetermined. So it's really important to end the meeting and say, look, we'll come back to you, preferably with a written decision, and that there's sufficient gap there in order to not fall into that trap. In terms of outcomes, well, termination is a common occurrence, and what justifies terminating an employee? Basically, it's where the conduct or misconduct is sufficiently serious enough to justify it, and it might be summary dismissal or on notice. But the fact that there has been misconduct found doesn't mean, of course, that dismissal necessarily automatically follows. So it's sort of a two-step process. It's determining whether the conduct happened, and then, well, it might be more than two, whether it's sufficient to be serious misconduct, and then if so, whether dismissal is warranted. And that requires some careful consideration. And certainly if the outcome is out of step with the seriousness of the conduct, then the decision to dismiss can be found to be unjustified. So it's not decisive just because it says in the employment agreement, for example, that this would warrant dismissal, although that is of assistance. So once again, we're back to this test of what a fair and reasonable employer could have done. So when we're thinking then about summary dismissal or dismissal on notice, it's really a sliding scale. So summary dismissal is obviously going to require the more serious end of the spectrum. So we might be talking about assault on a co-worker, for example. There might be at the other end of the dismissal spectrum on notice, that might be something that's been a series of issues that have involved various warnings and similar behaviour over a period of time, and so we might be looking at dismissal on notice. And of course, dismissal is usually involving an undermining of the trust and confidence that the employer needs to have in the employee. So thinking about whether those issues have been affected and being able to talk to those points. So essentially it is going to turn on the facts and the circumstances. It often also turns on the employee's response, as it should genuinely in terms of not being predetermined. But we've seen a real trend recently where employees have come out guns blazing on the attack, and it hasn't gone so well for them, where we have been privy to the discussions where the employer genuinely was not contemplating dismissal, but the way that the employee has attacked the employer, they have completely eroded that relationship. So we've noticed too that on the flip side, those employees who come in and go, gosh, really sorry, I didn't realise, or this is how I'm going to make sure it doesn't happen again, will actually be treated much differently. So, a lot does fall on the attitude of the employee and their response. Warnings, of course, are another option, and it can be really useful, often around misconduct type issues or perhaps unsatisfactory work performance. They are really an opportunity for improvement and can set out expectations or measures to meet in the future. To be fair, a warning needs to be explicit, describe how the employee's behaviour is deemed to be unsatisfactory, give clear information about what improvement will meet the employer's requirements, and how that improvement is going to be measured. So it's really clarity and objectivity are really important there. Alternatives to disciplinary action. What are the alternatives? We often have employers wanting to move directly to a negotiated exit. And that is not without risk, particularly if you're going straight into a without prejudice discussion without a process. And so the greatest issue there, or one of the issues, is that the employer talks to the employee about an exit, and then it shows the employer's hand that they want the employee to leave. And so even if that discussion is successfully held under a without prejudice banner, the employee knows that the employer wants them to leave. And they will look for things outside of that conversation, either in the process or in interactions, that demonstrate that the employer wants them to go. So it just provides ammunition to the issues and potential claim. So you open yourself up to this predetermination allegation, which would support a personal grievance. So if you're pursuing an exit type arrangement, it does need to be approached really carefully, and I'd say you need to do it on advice. And I would also recommend that it's under the umbrella of a formal process. So that's in part because of the way that the without prejudice rule works. So that's to encourage, as you're probably aware, the settlement of disputes with open and frank discussions, and without these issues being referred back to in any proceedings. But there are some principles that attach to without prejudice discussions, including that there must be a dispute. And so that is where we often see trouble, is that if an employer launches in and the employee doesn't even realise that there's an issue, there's a question mark as to whether without prejudice privilege actually attaches to that conversation. And if it's being implemented, it's really important to make sure that the employee is asked to have a without prejudice conversation with the impact of that explained to them, and that they say yes before any issues are raised. And of course, any correspondence being properly marked that way. And really, I do recommend that the employer has a viable alternative that they have considered in case that discussion doesn't work. And in terms of leverage, it actually is much better leverage to have it within a process anyway, because otherwise employees just don't really sort of believe that their employment's at risk otherwise. There was one decision, Blakely, where at the start of the meeting, before without prejudice had been raised, the employer said that they believed that their employment was untenable in the business, and then went on to make a without prejudice offer that was rejected. And then they resigned and were successful with a constructive dismissal claim, because those comments about the relationship being untenable were made before any mention of a without prejudice discussion. So there's a lot of care and steps that need to be followed there. If a settlement is reached, then that needs to be or should be recorded in a settlement agreement. There are the records of settlement, of course, signed off by a mediator, and there are advantages, of course, in that neither party will be able to bring a claim out of this employment relationship. But there's also the ability to control a whole bunch of matters around confidentiality, restraints of trade, intellectual property, non-disparagement, and issues around property, what's going to happen with that. So there's a real opportunity to tie things up beyond just sort of the bare, does this person work here or not? At some stage during a performance management process, we often find employers will often try to move to an exit discussion because of the time that takes to go through the steps, as I said before. But the difficulty is that what we find is that the employer often has put up with the situation for so long and often doesn't address it front on, and then gets so fed up that they want the employee to go as soon as possible. So we often see little time for a process, let alone any opportunity to improve. And so that's where we see a lot of employers trying to jump to that stage. Informal action Well, of course, a formal process might not be needed. So informal steps might be where you've got something really minor or a bit of a relationship type issue between a couple of staff members that can be addressed with a conversation. But of course, remembering that those informal discussions don't sort of give you pegs on the board in terms of a formal process, other than being able to say, well, we referred to you, we've talked to you about this before informally. So you're really making a conscious decision that you're not wanting a disciplinary outcome or a formal process outcome when you're going into those informal discussions. And look, there are a number of reasons, if you're looking at the informal, to actually flip it around and think, well, is this something that I should be raising formally? So obviously that would be where the conduct is more serious, but you don't know what you're going to find out in these processes. And sometimes you get trapped into this informal process that, depending on how you approach it, some employers then have kind of tied themselves up a bit, so they can't then go and start a formal process. So you've got to be really careful around that. The other thing is that you will often end up with a series of minor incidents. So someone might be late, or might be some attitude issues, or might have a small ding in the vehicle or something like that. But then over time, you tend to find that these recur. And so that's where, in hindsight, it was a good thing to have started a formal process, because then you can start to rely on all those things and move towards an exit of that person if that's what you think is appropriate, depending on what's been going on. And just an informal process doesn't really give you a resolution necessarily in some instances. So it's that might be reasons why you move straight to a formal process. And if you do go down the informal track, then make sure you're still documenting and setting out expectations. And it might be appropriate to say, look, this is sort of an opportunity to fix it, and if not, we'll have to look at formal steps in the future. Frustration at a lot of things some people have, but in terms of contractual terms, a contract at common law can be terminated by frustration, but in practice the courts are pretty reluctant to apply the doctrine of frustration, preferring to treat termination as either a dismissal or abandonment, and it hasn't had... It's sort of been thrust into the spotlight again in terms of COVID, but we still have our justification tests and everything that overlay everything. So case law and frustration in the employment context has made it pretty clear that it's something to be invoked rarely and has very narrow limits. And it sometimes is something that arises in relation to medical incapacity as well. So a high standard needs to be met, but many employment agreements actually anticipate and make provision, say for medical incapacity, they make provision for non-performance due to illness, and so they allow dismissal. So actually it becomes a contractual matter then. So you actually you're not dealing with frustration, because actually the contract does provide for this, so the contract's not frustrated. Likewise, in the COVID situation, many employers had a major events or pandemic clause. Brilliant things. They were great. They allowed us to do all sorts of things during COVID. But once again, the contract anticipates that, and so we're actually using a contractual provision. So I think the lesson from all of that is actually making sure that I think it's better to have it in the contract, better to anticipate these things. Now is a really good time, if employers don't have those sorts of clauses in, to make sure that they are in there. So takeaways from today. Preparation is key going into a process. Then, of course, process. So there's a lot of things that fit around the process that I've talked about, including these rules of natural justice, making sure that you're ticking the boxes. Each situation will be slightly different, but based on those same principles. making sure that there's no predetermination being heard by the decision maker and things like that. Outcomes matching the issue, as I talked about, and making sure that you take care around other steps. So, outside of the disciplinary process, you're not increasing risk and exposure. So, happy to answer any questions. Those are my details if you need them.